Hi, I'm John Zelenikow, now at La Trobe University in Melbourne, Australia, although my initial background is in fact in abstract algebra. That's what the PhD is. Moved into computer science, AI, and now into law. And for a very large period of time, about 25 years, I've been interested in the use of artificial intelligence uh, to help access to justice. And particularly, I'm indebted to Carl Branting, who very sadly is not here because he passed away. Now, 10 minutes is a very short time to talk. So if you're wanting to see the work I'm talking about, it's joint work with Amy Schmitz at Ohio State University in the Columbia University Science and Technology Law Review. And particularly coming from a common law domain, which all of us seem to be, we've been very interested in the rise of self-represented litigants, and who, for so many people, they cannot afford or do not want to engage lawyers in the legal system, and so they have to do it yourself. And the answer is, how can information technology and AI help? And talking about courts, and no talk would ever be appropriate in this area without discussing Richard Susskind, we think of two sort of systems. One, what I might call early AI, uses rule-based and case-based systems. And the second uses machine learning. And most of my research has been interested in the second domain. And what motivated it was, in fact, Carl Branting's work in about the year 2000. Now, Carl was a JD who had a PhD in AI from University of Texas at Austin, and was at the University of Wyoming in Laramie, and had a fellowship at the US Supreme Court. He wanted to show that AI could be useful. And what he did was he worked with the Idaho Supreme Court Technology Committee. And they looked at various different domains for building systems: sentencing, pretrial release, child support, protection order applications. Now, interesting enough, and that's a very big difference between Australia and the United States. In the United States, as I understand it, courts do not help with protection orders. Judges don't want to be involved because they feel that in an adversarial system where they make a decision, they shouldn't be involved in supporting one side. In Australia, it's very, very different. And people who need domestic violence support can get it from the courts. Anyway, Carl's idea was to build systems. Now, as I've said in red down there, and you would all know, that Carl sadly passed away on Thursday. What I now want to do is talk about some sort of systems that are currently available that are being used in the legal industry. And the most significant one is in British Columbia. It's the Civil Resolution Tribunal, and its goal is to be timely, flexible, accessible, affordable, and efficient. Notice nowhere in its material does it talk about being fair and just. The whole idea has been about it being efficient and effective. And you have 5 sorts of early disputes: housing, motor injuries, owners corp, small claims, and cooperative societies. Now, the important thing is that the British Columbia Civil Resolution Tribunal, the AI in it is rule-based, very early AI, very simple, but very useful. Why is it so useful? Not so much because of the brilliant AI, but because the Civil Resolution Tribunal has said litigants are restricted to using that tribunal. They cannot use face-to-face tribunals. It's got to be online. Now, paper-based solutions can lead to major problems for the digitally disadvantaged. And if I had been giving a talk 20, 30 years ago, I would have spent a lot of time on digitally disadvantaged. Now, with population changing, more familiar with computing, the digital disadvantage has become a lesser problem. But what the British Civil Resolution Tribunal system does is it provides potential litigants with assistance in accessing the internet. So in Australia, if you have a legal problem, there are community legal centres and trainee lawyers who will help you. What the Civil Resolution Tribunal has done is changed it around and said, we will provide you with technical advice, and they tend to believe that is easier. Now, it has been very successful, and we believe the reason is because it's the only forum in which residents can attempt to resolve their disputes listed above. So it's the government saying you will use the British Civil Resolution Tribunal. A similar system, and I've been involved with it because of sabbaticals and work, was a recogniser system in the Netherlands. But the difference with the recogniser system in the Netherlands was that even though the government supported it very strongly, it expected in the end that it would be financially viable and people would use it. And the problem was it didn't happen. Couples did not want to pay for their access to the system, and it was not commercially viable. The system has been restructured and to a much narrower domain, and it does seem to be successful now. Now I'm going to talk about two systems that we're involved for, and if you want to, you can go and look at some videos which will illustrate how they work. Now, Split Up used a predictive algorithm to determine a partner's BATNA going into a negotiation about marital property. So it essentially used neural networks and rule-based systems to give it advice about what would happen in Australia if a couple got divorced, how the property would be shared, and who would get what percentage. Now, the point to make, if you go and look at the paper, was despite using AI, there was a lot of conceptual modelling. It wasn't just a matter of throwing any data at algorithms. Now, 25 years later, the theoretical principles behind AI software haven't changed much, and Split Up is very valuable. But the computer software and hardware are much less expensive, and data can be much more easily stored. And in fact, the Legal Services Commission of South Australia in Australia have developed a system based on Split Up, which is now being used by Australian separated couples. Our Family Wizard is a very, and I'm talking about family law domains, is a very useful tool, but in a very different way. It's not there to offer predictions. What it does is it helps you schedule, track reimbursements, communication, creates logs, and also it keeps a record of how parents interact if judges want to use it. Family Winner was a system we also developed using John Nash's theory of game theory. And it's essentially what we did was we got parties to value their interests. Now, the values could be in words, not in numbers, but of course, you turn numbers into words, and then the software does trade-offs. So with these number of systems that we've looked at, particularly in family law, although we've only talked about 3 today, you can see hundreds in the paper. How do we envisage the ideal ODR system? Well, we envisage it as 6 different separate modules, all necessary for case, not necessary for every case. The first one is case management, where users can initiate a conflict, continuously access the data, be aware of.
John, 1 minute.
Then we've got triaging. Triaging is the very important thing that isn't currently being used. Think of domestic abuse. We've got, God, I can't see the other head. We've got advice. We've got communications, which everyone thinks of ODR. We've got decision support, such as trade-offs, and we've got agreement technologies, which when we wrote the paper weren't terribly common. But since 2021, generative AI, large language models, and ChatGPT have made agreement technologies readily available. Now, the important thing is, and the last thing in the project was, we went back and looked at 60 ODR systems held by the US National Center for Technology and Dispute Resolution. Almost all of them had communication tools. 2/3 had case management, but the other 4 areas were very, very lacking. 1/3 had advisory tools, and only about 10% had the really important area of triaging, decision support, and document drafting or agreement technologies. And so what we're sort of arguing is that in particular, in the last 3, the least available 3, we need to do work to provide such systems for self-represented litigants. Thank you.
All right, thank you.